All right. Hello, everyone. Some quick apologies here. My background is struggling a touch, so I'll be looking at that. But I wanted to welcome you all to today's live webinar brought to you by immigrationquestion.com, a networking platform and meeting ground where immigrants, employers, HR professionals, and licensed immigration attorneys come together to learn, exchange information, and stay current on U.S. immigration developments. My name is Nikola Ristic, and I'll be your host for today's session, L-1 Intercompany Transfers, Compliance, RFEs, and Global Mobility Solutions. The L-1 Intercompany Transfer Visa remains one of the most valuable tools for multinational companies who seek to bring key personnel to the United States. At the same time, it has become one of the most closely scrutinized employment-based visa categories. Employers today face heightened compliance expectations, increasingly detailed requests for evidence, and stricter interpretations of qualifying relationships and job duties. Understanding how L-1 petitions are evaluated in today's environment is critical for maintaining compliance and supporting long-term global mobility strategies. To help guide us through this critical discussion, attorney Jacqueline Lentini, Esquire, is going to be joining us. She's a Colorado-based immigration attorney with extensive experience representing individuals, families, and businesses across a wide range of immigration matters. Her work focuses on employer compliance, intracompany transfers, and global mobility planning, helping organizations navigate complex requirements of clarity and strategic insight. Jackie, thanks so much for joining us today. We're incredibly excited to have you.
Thank you for having me.
And now, before we begin, a quick little reminder, immigrationquestion.com is not a law firm. The platform serves as a public meeting ground and community where individuals can post any immigration questions they may have, learn about immigration topics, and engage with licensed attorneys who participate independently. To everyone joining us from Facebook, YouTube, LinkedIn, or any other platform, welcome. If you haven't subscribed yet, now's a great time. It's about to get interesting, so grab your notepads and pens, and let's get started. Kicking it off, Jackie, can you briefly explain how L-1 intercompany transfer visas work, and which types of companies and employees tend to qualify for this category?
Sure. Yeah, so we don't have an amazing amount of options for employers that want to bring foreign nationals to work in the U.S., but the L-1 has been around since 1970 and is one of our best tools. It is for an intercompany transferee, as Nicola mentioned, and that means that we're talking about a company that has at least 2 locations in the world. It could be a multinational large company, if you think of Volvo or Daimler Chrysler, something like that. But it can also be for smaller companies with, 2 locations in the world or 3 smaller entity like that. But the main thing is that the companies have to have what's called a qualifying relationship. If you look that up in the regulations, the immigration regulations are at 8 CFR 214.2L. If we have people out there that like the legal references, I'm not going to give a lot of references and citations today, but that's where you find the meat of this. And a qualifying relationship between companies is defined as there is usually 50% ownership of one company over the other. So it could be that the European company is the parent company and has 100% ownership over all its subsidiaries in the world. It could be that there's one individual that wholly owns 2 different entities, say one in Sweden and one in the US. So that's the basic principle. Independent contractor relationship does not work. Sometimes in the past, it may have been able to squeak by if somebody was an independent contractor, but I wouldn't try that now. And so after that, as long as the companies have the qualifying relationship, then you look at the individuals. And for an individual to qualify, they need at least 1 year of continuous full-time experience for the employer abroad before they can transfer. And so it can't be part-time employment. Like I said earlier, it can't be as an independent contractor. It can't be for stints of 6 months here and there. Out of the last 3 years, it has to be 1 continuous year of employment.
So just to make sure I heard that right on my side, this is a case of where companies have multiple offices, where that ownership is established like a subsidiary or 50% ownership, correct? Minimum? This is for full-time employees of over a year looking to transfer to that subsidiary or other office. So contractors, some of this other stuff. It's really just for the full-timers.
Yeah, and you can have less than 50% ownership over the two entities, but that's going to be a slippery slope and a harder standard to show because you'd have to show effective control. And I've been successful to do that in a couple of my client cases, but it's so much easier if it's just the math is there, to show 100% or at least 50% ownership. Joint ventures can count. Nonprofits can use the L category. Certain religious organizations that have a qualifying relationship can use it. So it is somewhat versatile in those areas. Do you want me to talk now about the different kinds of Ls for individuals, or do you want to wait a little bit?
If you think now is a great time to cover them, then let's do it.
Okay, so there's two flavors of Ls in which someone can come to the US. The first is L-1A, which is a visa for someone who is a manager or an executive. And so normally you think of someone higher up in the business. You could be a manager of people, but immigration defines professional level positions as someone who holds a bachelor's degree or equivalent. So the foreign national would have to have or be supervising people who have at least a bachelor's or equivalent, or an essential function, which typically it's harder to define because that is a little bit grayer. What is an essential function to a business? So if you think about a budget, if someone has, a huge budget that they're responsible for, like all the R&D development products to a business, that would qualify. And then the other category is L-1B, that's for specialized knowledge. And that has had an evolving definition over time. It's many different USCIS memos have been published about the standard for specialized knowledge over the years. And I think we've had, even under the Obama administration, they took a crack at it. But basically, it's to show that there is something either specialized related to the products and services offered or advanced knowledge about the product. So normally you think of specialized knowledge as someone who maybe is a tinkerer on machines, that kind of thing. It could be used for IT professionals as well. The good thing about the L category for either an L1A or an L1B is that it allows for dual intent, which means that the foreign national can be here temporarily in their L status while also pursuing the green card at the same time. Not all visas allow for that. So it's easier if it's just built into the visa and it's recognized as okay to do. The L1A has a maximum period of time given of 7 years, which is great. It's a lot. So if someone can qualify as a manager, that's the way to go. You get a lot of time. An L1B gets 5 years. Normally, either an L1A or an L1B is granted for a 3-year period, and then you can extend in 2-year increments beyond that.
Thanks so much for that. So now that we have a little bit of a better understanding of the different types of visas, I want to talk to you just for a second here about compliance. So we both know that compliance is a significant concern in these L1 cases. What are some of the most common compliance issues USCIS focuses on, and how can companies reduce this risk when filing or maintaining L1 status?
So back in 2004, USCIS created what's called the Fraud Unit, FDNS, Fraud Detection. I don't remember the whole acronym, but basically it was to allow officers to go out to seek out the H and L visa holders who are working for businesses in the US where there may be perceived fraud going on. So this, is somewhat of a pendulum swing. The economy wasn't all that great in 2008 with the recession. Hence, we had the creation of this fraud unit. And now it's also very active. They're expanding different kinds of fraud units within USCIS. So understanding what is filed by an immigration attorney in an L petition is really important. If you have an officer show up at a company site, you want someone knowledgeable to speak to them. They may want to see actually, where the L-1 has their office space or desk booth, something like that, and be able to talk to them about what their position is. It should be, their signature line and their business card and their LinkedIn should all match up to how the petition had been described within the L petition filed with USCIS.
Absolutely. So just making sure that everything aligns, that things are consistent, and just getting your ducks in a row, right? It's same sort of compliance talk, but you can't really overemphasize that.
Yeah.
And sort of piggybacking off of that, as you know, requests for evidence have become increasingly common throughout these L1 petitions. What trends are you seeing in these RFEs, and which aspects of L1 cases are most frequently challenged by USCIS?
That's a great question, because historically, Ls have been abused in that the government perceives them as potentially taking jobs away from U.S. workers. And there was this perception of fraud in the L visa category. So for many, many years, we had high rates of denials. Back in 2013, just at the California Service Center, there are many different service centers for USCIS to adjudicate petitions. But in 2013, it was a 40% denial rate just at one service center. And then under Biden, actually the RFE and denial rate decreased. So we were seeing some relatively good times for Ls under the Biden administration. Last year, the denial rate overall at all the service centers was down to 10.2%. So that's a huge benefit. But now with the Trump administration, he's not just targeting undocumented, he's going after all immigration. And so we are seeing an uptick in requests for evidence again. Some of them are just training issues. There was a big shift with the election in terms of officers leaving and new officers coming in. So some of the questions are really just, maybe the officer's not understanding how the petition is presented and what the standard is for an L. So that's why it's really good to start with the regulations and make sure you're hitting all the points. We had a really significant RFE, request for evidence, this summer for an executive questioning, well, how is this person an executive? So we had to explain in a lot of detail, including like how this person did performance reviews of all the subordinates under him to show that he really was an executive at the top level of the business organization. And then on the L1B side, it will come back, because I said that definition of specialized knowledge is a little bit murky. Well, how does this person really have specialized knowledge? It's easy to show if the person was employed for, say, 10 years at their company abroad. But if they just meet that minimum 1 year of employment abroad, you could get pushback from USCIS. So typical things to include are training certificates within the business to show that they really were trained on, a specific software tool that's proprietary to the petitioner, or to, if it's in machinery, that they really know how to do this. And, they may be one of only a handful in the whole company globally that can fix a particular machine. Organizational charts are helpful if we're talking about, understanding the chain of command, and if someone is a manager, showing that they manage professional level employees under them.
Absolutely. And that sort of jumps into the next question I had for you, which you already touched on here. So you mentioned, organizational charts for managers, certificates for specialization. Outside of that, from a documentation standpoint, what types of evidence are you really trying to get, given the fact that they carry the most weight when you respond to RFEs for, as we mentioned, these managerial, executive, or specialized knowledge roles?
Well, if it's for specialized knowledge, we'll sometimes include work product to show, that it really is complex and that not just anyone off the street could do it. It's not, job duties that are readily available on the U.S. labor market, and that may be because it's a proprietary software system, or it could be because it's manufacturing equipment made in Germany, and you have to do an apprenticeship in Germany in order to know how to do it. So documenting that, including blueprints, if that's applicable, for managers and executives, including documents about subordinates. So sometimes immigration will even ask for pay stubs. We try not to do that up front, but because it feels invasive, but submitting a LinkedIn profile, a resume is good. Something to show, if they're willing to share their degree, to show that they really do hold a bachelor's degree, we'll include that. There can be some pushback with, the entity abroad, especially with Europe, because of GDPR and privacy rules. So sometimes we have to look at workarounds for these kinds of things. And actually on RFE we had from last summer, the officer did not put any stock in LinkedIn. He said that's fabricated by the person. And so he wanted something, from the actual business, like a job description about what the subordinates are doing. So you have to get a little creative, and companies don't like to share this much information, but with the L's, you have to be so thorough. And my whole strategy is no one wants a request for evidence where immigration comes back and asks for more information, because then you don't know if it's going to be denied. It could be denied, or you could be left with 10 pages of questions that you have to answer before you get that approval. And so it can easily cost the petitioner twice as much as the initial filing if you have to respond to 10 pages of questions. The immigration officer starts with a boilerplate template, and sometimes they'll pinpoint the questions they really want to ask you, but more often than not, you're getting the whole custom boilerplate template, and you have to kind of figure out what the officer really is asking you, but you need to respond to it because you, as I said, you don't want a denial. An appeal takes a long time, and refiling would cost a lot of money too.
Absolutely. And so now that we understand a little bit more of, sort of what people really need for this L-1, what the qualifications are, some things to consider, taking a step back and looking at it at a broader level, how would you say that these L-1 visas fit into broader global mobility strategies for multinational companies, especially those that are considering or planning long-term U.S. operations or expansion?
So, as I mentioned earlier, we don't have a whole lot of tools in our toolbox. We have the E, the L, the H, O, T, N for Mexican and Canadian. So the L is really a good one. And if a company can meet the definition for a blanket L, this is where you can really gain some good traction. So for a company to have a blanket L, it means that USCIS approves the corporate relationship structure that I mentioned earlier, all those qualifying relationships. So you would get an approval notice with all the companies where someone's approved to come over from. And in order to qualify for that status, the company has to have at least 10 L transfers in a year, or US sales of 25 million or more, or a US workforce of 1,000. So I have a couple of clients that meet that standard, and we'll do the blanket for them, because after you get that approval from USCIS, you're done with USCIS. Then